So welcome everybody. I think we've got more than 100 people in the room, which is really exciting. Welcome to the Law Council of Australia's online event, Courting Innovation, Australia's Judicial System in the Context of COVID-19. My name is Dr. Jacoba Brasch QC and I'm President of the Law Council of Australia, which is a great privilege, and moderator of this event. I acknowledge the traditional owners and custodians of country throughout Australia and recognise their continuing connection to the land, sea and community. We pay our respects to them and their cultures and to their elders past, present and future. The Law Council is honoured to present this panel discussion this afternoon with such eminent panellists: Chief Justice William Alstergren, Justice Berna Collier, and Mr. Mark Woods, who is Chair of our Access to Justice Advisory Committee. For those of you who don't know, Chief Justice Alstergren is Chief Justice of the Family Court, Chief Judge of the Federal Circuit Court. Justice Collier is a Judge of the Federal Court of Australia. I'm not going to tell you about each of our participants. You have their biographies. You don't need me to read out what you can read for yourself. And that means, of course, we can devote more time to questions and answers. So we're here this afternoon to explore how the judicial system has adapted to COVID-19 and what effect this has had on access to justice. I'm particularly, and I assume because you're logged on, you as well, are particularly interested in how courts and tribunals have embraced technology and remote hearings during the public health crisis. And what's really interesting, I think, for all of us is what's the future? What did we discover we can do more efficiently online? What has to be brought back to a more traditional model? So I'll be asking each of our panelists in turn, what's the new normal look like? What's access to justice look like? And I'll be particularly asking Mark about equality of arms and criminal proceedings, because that's, of course, at the pointy end. I just don't see how you can have a jury trial electronically. Each of the courts and tribunals across the Commonwealth, the state and the territories all approached the challenges of social distancing slightly differently, and experiences of practitioners and their clients have been many and varied. One thing that I'll say that I want to acknowledge is the creation of the COVID list, the COVID-19 list, which was done in the Family Court of Australia and the Federal Circuit Court, and very quickly by the Chief Justice and his judges. Now, what that was a jolly quick response of the courts to deal with a situation people suddenly found themselves in with no notice. Children who couldn't go and see the other parent, despite court order, because of lockdowns or border closures. So that was just a really terrific response by the court using the technology that was available to us. Many of us too have probably discovered that doing things electronically can bring considerable savings to clients, efficiencies and savings. And so that's got a positive, an obvious positive for access to justice, but we have to not forget the digital poor, and that remote proceedings themselves can raise challenges for court users who are asked to embrace new technology, and there can be a frustration of the administration of justice. So the pandemic has forced us to rethink access to justice, and that's what this session is about. What have we learned? What do we need to know for the future? How can we do things different, but perhaps even better? So my first question is to all panelists. The pandemic, of course, has forced courts across the country to consider how otherwise face-to-face proceedings can continue in the context of travel restrictions, lockdowns, social distancing. From your various perspectives, and I'll start with you, Chief Justice, what's been the single greatest challenge faced by the judiciary and the legal profession when having to adapt to this changing landscape?
Thanks, Jacoba, and thank you very much for having me on with such an esteemed panel. Can I say, first of all, the biggest challenge, I think, from our point of view was to enter into what we call a significant digital transformation. The most important person in the court was no longer the Chief Justice or the CEO, it became the head of the IT department. And I have to say that our digital natives, the wonderful young associates, suddenly became the people that had all the energy and had all the confidence to be able to transform. So from our point of view, our biggest challenge, because of the kind of work we do, particularly in the family court and the family law area, was to assure people that we weren't closed. Our litigants rely so much upon the courts and the need to be able to make sure they can enforce orders, to make sure that when the borders, for instance, closed and contact centres closed, schools closed, they knew that we were still open to actually be able to deal with their applications and deal with their matters that affect their daily lives very quickly. And secondly, so first of all, part of it was about education. Secondly, was that being able to hear cases from literally having to go to shutting down face-to-face hearings, as I know that Justice Collier and others had to do in the federal court, shutting those hearings down on a face-to-face basis, but allowing an opportunity to be able to move firstly to telephones, then to Microsoft Teams. And I have to say, part of it was education. I didn't have to say that a lot of people didn't even know what Microsoft Teams was, let alone which one to use, Zoom, Microsoft Teams, FedEx or other matters, and or WebEx, I should say. And one of the interesting issues for us was to educate people. Now that included 110 judges in 43 locations across Australia, 800 staff and 60 registrars. And the great thing from our point of view was we were able to do that, like a lot of other institutions, within about 3 weeks. Now, I don't want to be unkind, but if you can imagine that most judges' average age is about 60 or over, to try and get them to use a different type of computer system was a very interesting aspect. Not only am I incredibly proud of them, but they became competitive. It wasn't so much, can I do it? It's how quickly can I do it? Not going to do it better than the judge next door. So we were able to maintain a clearance rate because of our backlog. We couldn't afford to let it increase. We maintained a clearance rate of over 90 to 95% during that period of time. But to answer your question, the biggest challenge was, I think, really the digital transformation had to occur and to bring everybody with us when we did. The profession were fantastic. They just hit the ground running. They were incredibly kind and decent. They were progressive and pragmatic, and they assured their clients that this was something they shouldn't be worried about, that they should engage. And they helped us ensure that people respected the spirit of the orders that were being made and to obey them wherever possible. And if they couldn't obey them, then at least to adjust them. So I think probably, obviously, the digital transformation, and the other thing was communication with everybody. The communication part was huge, not only with the profession, but with the litigants. I found myself having to get on radio, get in the paper, having to actually communicate that we were both still open, but also that they should try and comply with court orders. So the 2 biggest challenges for us.
Thank you, Chief Justice. Now, before I ask you, Justice Collier, can I say to everybody listening, if we've got time at the end, very happy to take questions and use the Q&A. So down the bottom of your screen, there's a Q&A thing with 2 little bubbles. Send any questions through to those and we'll get to them at the end if we can. Over to you, Justice Collier.
So the biggest challenge for the court? I haven't really got much to add to what Chief Justice Alstergren has said. It's occurred to me that we have accelerated dramatically the engagement of judges with IT and also with conducting hearings with litigants who are not there in person. We're a national court, like the Family and the Federal Circuit Court are, of course. So we have litigants from all over Australia. We are accustomed to conducting hearings by phone and also people coming in by video. Having Teams and having all our judges become familiar with it, I think was a major challenge. And it's something which we all have embraced. As Chief Justice Alstergren said, the associates have been fantastic, and you're right, the IT person became the most important person in the court in many ways. So for us, it was really a case of embracing digital technology and also becoming much more accustomed to having hearings conducted without people there in person, particularly witnesses who were being cross-examined. Credibility is such an important, obviously, credibility of witnesses is critical, and having to accustom ourselves to assessing the credibility of witnesses, you know, really engaging with counsel and legal practitioners and litigants in person over Teams or WebEx or Zoom or whichever technology was being used. I say WebEx because I'm also on the Supreme Court of the ACT and they use WebEx, so I've come accustomed to that one as well as Zoom, which is today. So yeah, that's my contribution to that conversation.
Thank you, Judge. Mark, you can talk to us, of course, from a different perspective, practitioner land, and engaging with your clients. So challenges, we've had challenges faced by the judiciary, part of the question. You can look challenges for the legal profession in your answer. And I said in my introduction, if you want to also talk about criminal law and equality of arms at this point or another answer, you're more than welcome to do so. You're on mute, Mark.
I was just going to tell you, so good am I at this sort of virtual presentation that when the Chief Justice moved off screen, I started to stand up because I thought court was adjourned. Can I say to you that I'm coming from the land of the Gunai-Kurnai people on whose land my office is, and I pay my respects to them as well as those to whom you've referred. In the old days, when we wanted to have some sort of innovation in the courts, guess what we lawyers did? We formed a committee, and that committee then had a discussion, and there was, as Sir Humphrey Appleby would say, appropriate give and take, backwards and forwards, and at the end of the day, having regard to the usual parameters, a suggestion was made that somebody should do some research. That just wasn't possible in relation to innovation. Otherwise, as the Chief Justice rightly says, the whole show would have closed down, and we would have had, mark my words, mayhem, particularly amongst those who are formerly of an intimate personal relationship. The biggest single challenge has been inconsistency from a practitioner's point of view. For those who have a general practice, we have had choices up to 8 different platforms that needed to be installed, understood, and compatible with the hardware which was in various offices. We had to then cope with the idea of a virtual courtroom when somebody, maybe a litigant, was in a car park somewhere outside Bunnings, just near the sausage sizzle, and really not able to give the virtual courtroom their full attention, where, you know, some, not members of my branch of the profession, of course, but some barristers were known to wear only their underwear below the desk. And it was a little difficult to get your head around the concept that, look, here we are in court. The more practical issues have been things like sharing of documents. You know, it's easy just to pass something across the bar table. It's not that easy when you have to scan it. You have to sort of do something like put it up in front of it. That's really hard. Finally, what's really been difficult to come to grips with has been private communications, generally between those at the virtual bar table and themselves, or more importantly, if the client is not there with you. Those are the biggest challenges.
Thank you, Mark. I think we've all got stories of people that forgot to put themselves on mute when they were making the cup of tea, or the people wandering behind. I've seen a lot of cats, people's cats in the background as we've been doing things, and the occasional dog bark, but in any event. So thank you for that. I've got another question for the 3 of you. A greater reliance on technology by courts and tribunals has potential to improve access to justice by removing distance barriers. You know, I'm from Queensland. If you don't have to travel from Mount Isa to the court in Cairns or Townsville, that's a huge saving in time, in money, in efficiency. Costs, reduces costs. There's options to reduce delays as well with face-to-face hearings. But there's a potential for access to be adversely affected or impacted due to a digital divide in Australia, with varying levels of technological literacy and infrastructure for those interacting with the judicial system remotely. When life returns to some kind of, I don't think it's normal, it's never going to be normal, some kind of new normal, which of the pandemic related measures do you think should be retained in the longer term in the interests of access to justice? And what do you think should be wound back as no longer a required priority? Judge Collier, can I start with you this time, Justice?
Sure, no worries. Thanks, Joanna. Look, in the long term, I think we will continue to conduct hearings using a mixture of in-person and via Teams. I believe that many people prefer to have in-person hearings, and I know that judges tend to, as a general rule, prefer to have in-person. As I said before, where credibility of witnesses is an issue, for example, a Teams appearance and cross-examination of a witness is a poor substitute if it's over Teams for everyone being there. Further, if there's something like a Teams outage, you know, the words which strike terror into us all, or similar, and often there is, the matter can be derailed for indeterminate periods of time. But where parties are interstate, for example, or in other parts of the state, and Queensland's a very big state, which is where I am, case management, for example, is definitely something which I think we will continue to conduct on Teams. And further, on appeals where there's another judge located interstate, and if it's like a short matter, for example, for half a day, interstate judge may choose to attend by Teams. I'm actually doing that in a matter I've got where I'm one of 3 judges, the other 2 are in Melbourne, everyone's in Melbourne, but the matter's half a day on a Monday morning, and it's still daylight saving. So rather than go down the Sunday, I've sort of spoken to my colleagues and they are content for me to come in by Teams. And I've got other matters where other judges are coming in similarly, where matters are in Brisbane. So basically, we will endeavour, and I think we will do situations where, cases where people are coming in as a preference, but I think we will be much more open to having matters conducted by Teams. By Teams is better than by phone. If possible, at least you can see people.
Thank you, Judge. Over to you now, Mark. If you can, what continues and what needs to be wound back?
Can I use one word to describe what I'm about to say, and that is argument. Argument necessarily involves the engagement between 2 or more people leading to a particular result with the hope of persuading one side or the other of your point of view. And that's where digital communication falls down. And it falls down because you don't have the same ability to impress the person with whom you're arguing or the person before whom you're arguing because of a variety of factors. It's simply not an organic process. Having said that, the revolution that we've been through has been fantastic for access to justice. The idea of scarce resources, whether they be private funds or taxpayer funds paying lawyers to sit around for 2 hours for a 10-minute mention in court, are gone, and rightly so. We as a profession would far rather help 10 more people using that same amount of money than just having the entire amount of money on one person. And that's what traditional case management has caused over the last 20 years. So things like mention hearings, directions hearings, in the criminal sphere, sentence indications, all of those sorts of things can and should be done, in my view, in the way in which we've learned to do them. There's one issue that probably applies as much in transactional legal work as it does in proceedings before courts, and that's the question of authenticating documents. There have been some new practice directions. In some cases, there have been state government regulations which have mandated the ability to authenticate documents, be they signing contracts, giving undertakings to courts or whatever. And we really haven't seen whether or not they're going to stand the test of time like signatures and seals used to. And I think that the profession and the judiciary, as well as government, need to look at the question of whether or not we're satisfied that there is sufficient efficacy in those regulations which were brought in haste, lest we be in a position where the Chief Justice has to decide upon a contravention application in the face of a litigant saying, oh, no, I didn't tell my lawyer to sign that, as some sort of a defence. But that's a practical issue. But essentially, any presentation to any court which involves organic argument or serious cross-examination should, in my view, be conducted in person.
Thanks, Mark. For everybody listening, the Law Council is doing a lot of work with all of our state and territory law societies, bar associations, on the electronic execution of documents, on trying to get it harmonised. For example, in Western Australia, yes, an affidavit could be electronically done, but not a deed, not a will, where it changes. The requirements in, for example, Queensland in signing documents, requires business contracts that might be 500 pages long being sent, laboriously, the whole thing, even though you've just got to sign the last page. So that's something where I can assure you all we're working on a harmonisation, if you will, because that's good for business, but also what are the documents that should continue. There's certainly, as I consult with presidents around the country, there is certainly a sense, the Law Council is federal looking. So what I'm saying is a matter for state and territory jurisdictions. Wills are probably something that the states and territories will want to come back to face. Hard enough to try and work out capacity of the person face to face, let alone online. So there's a watch this space in that. And that's, I think, Mark, one of the big balancing acts of what should stay and what should go. Chief Justice, what's the future look like? And what stays, what goes? And I'm wondering if you would be so kind to also factor into your remarks how technology might help where there are critical safety issues, where someone would bring a safety plan and they might be in another court or something like that, whether there's any learnings out of this that can help with those cases.
Yeah, look, thanks, Jacoba. I think that's a really good point. Look, from our point of view, there's a number of things. One is that we obviously do a lot of regional work. And one of the things we found, whether it's right now in those poor people in regional Queensland and New South Wales that are suffering so badly by the floods, or it's a pandemic, or it's just a tyranny of distance. As you said before, one of the great things that can help us is technology to make sure that we can service and have access to justice to regional people, so that, for instance, they don't have to wait for the judge to come on circuit. They can be reached by a senior registrar or registrar initially. They can deal with the judge before the judge gets on circuit, or even the judge can circuit more electronically, which I think Mark was talking about as well, in relation to what we can do. Appeals, obviously, as Justice Collier was mentioning, some of the appeals can be electronic. We had an appeal division which was travelling about 21 weeks of the year. A number of appeals can be heard electronically. I did one with Justice Strickland and Justice Kent that went for 5 days. Well, I think it probably went for 4. And we were all we were sitting in 2 different states, and it was appropriate to be able to deal with. Justice Kent did a very difficult electronic trial. I agree with what Mark's saying about the difficulty of having a fair trial electronically compared to face-to-face. And I know there's a lot of learning in England about the fact that it's up to each judge to make sure it remains a fair trial. So how far you go with some of those difficult trials electronically rather than face-to-face is obviously a real concern. But I would like to think that we would have at least 30% of our cases going forward, or our, the activity of the court going forward, being electronic. Obviously, things like divorce lists and other things are easy, but some of the appeals, certainly some of the regional areas. But the other thing is risk. Risk is so incredibly important in our areas, whether it be various areas, not just in family law. And the idea of being able to have vulnerable parties or parties at risk being able to attend, they don't have to come to the courthouse. I mean, it sounds trite, but that actually, in this day and age, they can actually appear in a very safe environment electronically. It can still be a controlled environment, and they can be subjected to cross-examination. They can be, they don't have to face their perpetrator. We can even have, would you believe, electronic mediations where risk would normally prevent discussion about a mediation, but where you can enter into different rooms electronically, and people don't have to face the other side or the perpetrator. There's a lot of interesting things we can do to reduce the psychological damage of some of these hearings. And I think we will be enhancing and accepting as much of the learnings as we possibly can in relation to that. We've now finally, and this is probably a terrible admission to make, but finally, because of the pandemic, we got a digital court file for the first time, and in family law cases. So you can assure that we'll keep that. But I think also when you're dealing with it as a national court or a court which spans across a very large state, it's imperative that you have access to and embrace the digital transformation that we've now got. And as I said, we've got 14 registries in either regional areas or in capital cities, but we've got an extra 33 areas that we service regionally, and it's just so incredibly important that people feel like they can take part. And one of the great issues is the COVID-19 list, which you very kindly mentioned, which I'll credit to Angela Lynch, because it was probably her idea, and then you helped her write the letter which came to me. We have had people from all over Australia accessing that where a case, if it was COVID related and it was urgent, was able to access the court within 3 days, 3 business days, which is probably almost a world first. People that accessed that were from anywhere from Dubbo to southern Tasmania to the top of Queensland to Western Australia, or not Western Australia, but to Northern Territory. And that wouldn't have been able to happen if it wasn't electronic. And the idea that people could feel like they had the opportunity to deal with that is very important. That same system, that same learning will happen when we do a national contravention list later in the year. So there are some really good opportunities. I know perhaps we're looking at it from a glass half full, but I really think there's some great opportunities, and I think we can significantly enhance our access to justice because of it.
I'm going to ask a follow-up question in a minute, Chief Justice, but one of the questions I'm not going to ask the 2 judges here. I'm simply going to adopt the question as my own and say, please, oh please, if you're doing stuff electronically, particularly longer matters, could we have more breaks? I think I think one of the learnings from last year is if you're sitting on your butt all day from 10 o'clock lunch break, then afternoon to 4:15, the headache starts at about 4:30 from just looking at the computer screen. So I think we'd all be grateful if you could factor that in. Can I say on the safety point for the people watching and listening, something that didn't dawn on me until last year, I'm an arbitrator. I arbitrate family law matters, a Reg 67B arbitrator. What a fabulous way to do arbitrations on Zoom. where there are safety issues, where there's family violence, where you've actually got it. And I did do a few last year where the parties, there's not even a chance that they're going to come into contact with each other on the way to the ladies or the gents because they're separate. So just think of that in your dispute resolution sort of toolkit that you have. If you have one family violence, family violence issues are critical, separate them electronically. Judge, I'm going to be Chief Justice, I should say, I'm going to be cheeky and ask you a follow-up, which is completely not a follow-up at all, but I'm going to ask it anyway. The future of the harmonisation of rules. If you've given us what the future of the court looks like, if you could also tell us a little bit about that for the family law practitioners listening.
Thanks, Jacoba. Look, going back to 1999, there was obviously a second court that was started doing family law. And as a result of that, we had this bizarre situation when I came in 2017, where you've got two courts effectively doing 98% of what the other court's doing. But they've got different rules, different forms and different case management principles, which is quite bizarre. I think one of the things, there's not a lot of harmony in opinions in family law, but one of the things there is harmony in relation to the fact there should be a common set of rules, forms and case management, not just for practitioners, but it's also for the poor old litigants. So what we did was we put together a committee. People thought I was mad trying to do this, but we put together a committee with the great Chris Jessup, who Justice Collier will know very well, who was a fantastic and very highly regarded federal court judge who did a lot of work on rules and things. Justice Jessup agreed to be the independent chair. We got two very good black letter lawyer barristers to assist us, and we put 7 judges together who'd been on, 3 had been on one court, 3 on the other, and 1 had been on both. And I wanted them to come up with objectively the best set of harmonised rules we could find between the two courts. You can imagine there's a lot of history about this exercise, and they hadn't been able to do it in 20 years. Well, I'm proud to say that we've got to the stage where we've actually got the final version of the working draft, which is going to the Rules Committee on the 22nd of April. And once we've got that, then the judges have been totally consulted, all the user groups, including the women's legal groups, the men's legal groups, legal aid, all the judges, the state and territory bars and law societies, the Law Council, of course, importantly, and also the ABA. And we've put together this set of rules that will go to parliamentary drafters because they've got their own language. So they'll do that. And then I'm hoping by July, we will actually have a set of rules that we can then put to the judges of both courts, obviously separately. And I want them to vote on it. Under the new legislation, I can, for the first 18 months of the new court, bring in rules, but it's very important to me, and I think it's very important to all the judges. They have ownership of these rules, having properly been considered by the profession. And then what we will do is do town hall meetings in each registry, letting people know exactly what the ramifications of the rules are, but they'll be very much in the same form as they've already seen. And that'll make a drastic difference, I think, to not only family law, but also the general federal law aspect of it too. We're going to look at going forward, and also case management. We have a new court starting on the 1st of September. And it's going to be critically important that those rules are in place, obviously, for that new court. And also people totally understand what's required. And it's an incredibly exciting project now that it's been cast upon us by Parliament. It's now an exciting project to reorganise and to, if you like, redesign a system that the Australian public deserve. A system of efficiency, of proportionate costs, and of course, I think a fair system, which I think Mark was talking about before. So it's an enormous challenge, but the harmonisation is very much a common theme through that. And we think going forward with all the goodwill that everybody's expressing at the moment, and all the extraordinarily goodwill that we're getting from the Law Council under your leadership, and of course from the ABA, as well as the state bars and law societies, we're very confident we'll have a very good outcome.
Thank you, Chief Justice. You absolutely, oh, I almost fell off my chair. Heavens, there we go. There was my own digital divide disruption. Thank you. And you're absolutely right. Of course, the Federal Circuit Court's not just family court. There's the general federal litigation that will apply to. Thank you. Justice Collier, your court has a high percentage of applicants, or litigants indeed, who are self-represented. How has this influenced the responses, the court's responses to COVID-19, and the measures that your court adopted to accommodate unrepresented parties? And again, what's the future look like?
Yes, you're right, Jacoba. Many of our litigants in the Federal Court are litigants in person. We have particular concerns about those who are in migration detention for whatever reason. That's really caused a lot of our judges, and including particularly the Chief Justice, a lot of angst. The court has endeavoured to seek pro bono representation of such litigants where possible, and we've actually put a lot of effort through our registrars into doing so. So I don't think I've had one person in migration detention appear before me since the beginning of COVID who has not had some sort of representation. We've issued a practice note, special measures in response to COVID-19, which allows some documents to be signed electronically for the present, and we've accepted filing of unsworn affidavits, or on the understanding that they'll be later sworn or affirmed. That's something that Chief Justice Alstergren was talking about, I think, or maybe it was Mark talking about before. And we've tried to facilitate litigation that way. But in relation to litigants in person, we do know that there are people who may have difficulties with the technology in order to conduct or participate in hearings. So far, I have, although I've had some litigants who have been unwilling to participate, I haven't struck anyone who has been unable to participate in Teams because of what technology they had access to. But I know some people in the court who have had some litigants in person with problems. What we've tended to do with people who may not have had the latest whiz-bang computer with a camera, we allow people to dial in if need be. So we try to facilitate people participating in Teams meetings where they haven't got a computer by at least dialing in. Having said all that, we have, at least in Brisbane in any event, we have reverted almost to normal hearings with people coming in now. And I think that's something which is happening around the country in the Federal Court. To the extent that people can come in, of course, back to litigants in person who are in detention, maybe not. But we are trying to get back to as normal as possible with our hearings.
Thank you, Judge. Mark, what are the instances where, as flashbang as all this technology is, there is simply no substitute for in-person?
I'm in total agreement with what has been said by the Chief Justice and Justice Collier about the attempts by the court to adapt. But the sad reality is that in so many of our jurisdictions, not the least of which is the criminal jurisdictions, that those who appear before it have issues with homelessness, they have issues with their mental health, if not their intellect, they have issues with the people with whom they're fighting, and they simply have difficulty articulating their position so that a judge can do their duty and provide justice. It's just impossible to ask our judiciary to judge a matter in circumstances where they are unable, by reason of the technology, to seriously get a grip on what the case is. So, in those circumstances, there must be a default provision so that a judge can say, look, this just isn't working. I'll make some sort of a decision now just to tide us over, but this just isn't working. And whether that's the fault of the litigant, whether it's the fault of the technology, whether it's the fault of no one in particular, it just hasn't worked, there must be a situation for the court of its own motion to say, notwithstanding the rules which say this is going to be done, the judge needs to take some sort of stand to ensure that justice is done. You mentioned earlier on, Jacoba, about the question of doing jury trials. The whole nature of a jury trial is that a jury is collegiate. It's a group of people who are going to be asked to discuss something. If they each have different perspectives caused by the two-dimensional nature of a virtual hearing, then how on earth can they get together and start to make some sort of decision, let alone the issue of seeing the witness in person and judging their demeanour, body language, and all the rest of it. So those are the things that really stand as the big challenges moving forward.
Mark, can I just ask you to come back on again? Equality of arms. There is, when that concept became part of our rule of law or our rich legal tradition, there's no way in the world there was contemplation of trials by team or Zoom, etc. What are your observations about equality of arms in this digital age that we're in?
Let's take a person who is intellectually challenged, who has had their children taken by a state protection authority, and they don't even have a smartphone at that point. But they're given a brochure which says, you look up on the website and find out how it's going to work. And in the meantime, the Department of State, against which they are expected to litigate, has all of the resources available to them, including well-trained advocates who have been to webinars like this, who have been able to say, well, this is the best way to present our case. If that's equality of arms, frankly, I've been around too long. It simply isn't. And that's why I make the point before, we repose a lot of trust, quite rightly, in our judiciary, and it's going to be up to judicial officers to look very carefully at whether or not people are really struggling to put their point of view. Now, they do that with people in person. We see it all the time, judges looking after litigants in person in the sense of saying, well, hang on a tick, I'm not going to be able to judge this properly because they can't get their case across. But it's so important in this digital age, because otherwise the injustices are just unimaginable.
Can I ask, thank you, Mark, can I ask our two judges, and this is a question that's come from someone in watching land, how do you, when someone's being cross-examined online, how do you know someone's not in the room, or there's no intimidation, or the answers aren't, someone's there telling them what the answers are? Chief Justice, you're off mute first, so how's that work?
Jacoba, it's interesting you actually asked that question. It's a really good question. We've all had situations, and I'm sure that Justice Collier has been the same way, where we've wondered who's in the room with them, or whether you've got a lawyer, right next to them, which is fine, but it's more likely if you've got someone else who's affecting them. I did in one of my hearings, I did actually ask the litigant to, after telling me there was no one in the room, to actually turn the camera around and show me who else was in the room or what was in the room. And I found there was 8 other people sitting there coaching them on. I think from what Mark was saying too, if people are unrepresented, often they don't appreciate necessarily what's expected of them as well. But you can have controlled environments, and I think you can have certain criteria which you require. Part of it may be having a wider camera so you can actually see who's there. Obviously, you hope people will accept the opportunity they've got to provide things in a certain way. If people are, for instance, being cross-examined and they're represented, but they're on camera rather than being in the court, you'd think that you could rely, I think you should be able to rely upon the profession because of their duty to the court. Unrepresented litigants are much harder, but to be fair to them, sometimes the difficulty of being a little bit uncertain as to what they're doing has to be balanced against safety risks. So in urgent applications where it's not possible to bring people in to hear evidence, it may be different, but certainly for final hearings, the optimum is, of course, to have people present. The other thing I should say is there is technological issues too, which I've found where I've had people who have given evidence even in a solicitor's office and the technology hasn't been particularly good from their end, which meant that even the transcript didn't properly pick up their evidence. And that became a real problem.
Can I just add, Chief Justice Alstergren has just said, yes, I've had similar issues as well. I had a native title matter in which some of the, a lot of the transcript was just not picked up. So we had to have somebody actually sit down and listen to the team's recording so that they could actually complete the transcript, which is very worrying. I also worry sometimes about people being in the room. But just that's one thing, just to answer something that Mark has said. I can only comment on my role as a judge, but look, you can actually see Mark, Jacoba, Chief Justice Alstergren and me actually quite well. When you're in court, you can't see our faces that well. We can see you that well. We can see you up close. I can see everything, every nod Mark is making. You know, to the extent that there's a problem with not being in the room, I just wonder to some extent if it's sort of counterbalanced by the fact that you're actually in, the judge is in your face and you're in the judge's face. I'm not sitting way away. I'm actually quite close to you. You can actually see me quite well. At least I think you can. So I just wonder to what extent that is actually a counterbalance to someone being in the room with you.
The tradition, I no longer ascribe to the you've got to see the whites of their eyes, as used to be, you know, in cross-examination. And that was for some trials that were conducted for safety reasons well before COVID, where the family court judge was in Cairns, I was in Brisbane with my client. We saw everybody I could actually see my client, because in some courts they sit behind you. I could see when she was crying about things, you know, when she'd ordinarily be behind me. My cross-examination of the father in that matter, absolutely, as you say, Judge, I could see him better than, so there's an interesting aspect to that. Judge?
Having said that, just add, if I'm shaking, if my hands are trembling, you can't tell. So the body language aspect, which might fall away. As far as the face is concerned, I can see you all very well. And I presume everybody who's attending this webinar can do the same.
Thank you, Judge. Now I've got a couple of questions here from the panel. And this one I might start with you, Mark. Open justice. You're chair of the Access to Justice Committee. Open justice, the importance of the public gallery that exists in face-to-face hearings. We've lost that by going online. That was a necessity last year. But what are your thoughts about the importance of, you know, justice being done, being seen to be done?
Absolutely right. And it's something we haven't spoken about up until now. I think not only the issue of other members of the community that are interested in a particular case, family members, neighbours, friends who want to come in and sit in the back of the court and see what's going on, right through to groups of school children whom we're educating about civics. They want to come in and they want to sit in the back and they want to see what in real life happens as opposed to what they see in the movies. That's all part of justice being seen to be done. The reality is, of course, that the technology is there for people to join this sort of virtual discussion and therefore virtual hearings subject to, you know, passwords and all the rest of it. Whether that's the same thing or not, I'm not qualified to say, but it has been. You talk to any legal studies teacher, any civics teacher, you know, in year 10 around the country, they can't get their kids in to see what's happening. They don't even get to then talk to a real judge or magistrate, and that's a tragedy.
There's the difficulty, though, with people attending online. It's very unfortunate. I think it was in the federal court, Justice Collier, where unbeknownst it was being recorded and live streamed to Facebook. So there's a security issue there. Chief Justice, open justice. There used to be, before your time as Chief Justice, Chief Judge, there were a group of older people who would every Tuesday afternoon come to the family court the first Tuesday of each month, and they'd pick a court and they'd sit there, and that was the outing. It was great. Occasionally they'd talk a bit too loudly, or don't like him, or she's, and they sometimes comment on your questions, but that's open justice. What are your thoughts on the balance?
It's actually really interesting. We had a very good advisory committee with Chief Justice Alsop during COVID when it first started. And this is one of the areas that was really, really of concern to both of us in relation to the courts. And as Mark said, for people to feel like there was open justice, obviously in the family court area, you've got Section 121, which prohibits the publication of proceedings and what goes on with proceedings. So that was to somewhat limit it. But having said that, people still felt the need to have open justice. We did do some practical things. We ended up having screens outside, for instance. So when we would have a hearing, we'd have screens outside the courtroom, not the court building, but the courtroom, so people could come in and watch if they needed to. We indicated, we actually had a protocol, and I think the federal court did too, and Justice Collier will tell me if I'm wrong, but certainly to enable people, if they wanted to apply to the judge and to, through the associate, I think, to get a link into the hearing. Certainly for our courts, that's what we ended up doing. We're a little bit more complicated. But a lot of the migration cases and other cases, it was the same thing. Not a lot of people took us up. It wasn't that interesting. They wanted to come and see it. But I think it was important to have that feeling of open justice. And also, I think it helps with people making sure they understand, A, what's going on, but B, that it's a fair hearing. And I think that's one of the difficulties, I think, with a lack of open justice is invariably people's perception about our court system has got to be protected. We've got to make sure we educate people the right way. And, you know, whether it's people being cross-examined, it's people having, you know, having to deal with making submissions, it's seeing unrepresented litigants be able to get a fair hearing in front of a judge. All those things are incredibly important, but we have to adapt. And I don't think it was as much of a problem for us in our jurisdiction, particularly in family law. I think in the general federal law area we were very worried about it. We made sure that people did have the opportunity, and some did. And hopefully they were mostly muted. Otherwise they had to be muted because they did make some running commentary from time to time.
Okay, but just commenting, just following up what Mark and Chief Justice has said, just two things. One, we encourage people, anyone who wants to watch a case can join by Teams. I need to check again, but I understood that we advertise or we make available the Teams link to anybody who's interested. I completely agree that justice has to be seen to be done. But, you know, at the moment, on the 24th of March, 2021, even with in-person hearings, there's a problem. When you think about it, people have to socially distance. My courtroom 2 in Brisbane, we can have up to 17 people in that courtroom at any one time, because you just have to have, so, you know, have to have a certain number of people for the social distancing and so on. And there's a problem. So, you know, you have people coming in, but then, you know, I had a situation the other day, it was difficult. We had 18 people in, so I had to sort of very reluctantly say, look, I'm sorry, somebody has to leave, and we'll make arrangements outside if it's a witness, if not a witness, but it's like a member of the public. Luckily, we're under legal representatives, happily left. with a computer with them and Teams in. It's not ideal, but it's still an ongoing problem until things are sorted out with COVID. Even in-person hearings, problem.
Can I add to that? Obviously, I assume there are some people listening who whose court is a local court that cannot fit 17 people in. Justice Collier is, of course, in the Commonwealth building that's, I'm pointing there because it's literally over there from my chambers, and it's a large, expansive court. But one of the things I noticed, and no doubt a lot of you online noticed, it's all very well to say be socially distanced, but if you're in one of the smaller, more local courts, then that's a real hamper. It would with a number of people, I suspect, Justice Collier would think 17's a luxury because their court sizes are so small. Our Brisbane Supreme and District Court was able to continue working here because, again, they're large courts, but of course, courts more regionally and remotely had difficulties. Now, very last question, and if anybody, and I'm happy if only one person wants to answer it. We've had a question online. Do any of you know how our experience and how we've managed fits in with any of our overseas counterparts? Now, if any of you have any insights on that, thank you, Justice.
I can comment. I'm also I have the honour of being a judge at the Supreme Court of Papua New Guinea, which, as everyone knows, is having COVID challenges at the moment, serious COVID challenges. Some of the judges have COVID at the moment, and it's a real issue up there. However, the court continues on because of significant, I could talk about this for ages, but I'm not going to, I'll just try to be brief. Because of significant connectivity issues throughout Papua New Guinea and coverage by internet, and also court sizes, as Jacoba has said, having hearings conducted by teams is of limited utility. One of the things the Supreme Court, which is like the High Court of Australia, the equivalent, has done is to have some hearings on the papers. A practice note was introduced last year to allow that to happen, because it's really contrary culturally to the way that people in Papua New Guinea have hearings. They expect to have people there and have the judge there, have everybody there. But they have had some hearings on the papers, but it is a problem, a real issue.
Can I indicate that I've been speaking quite a lot to the English courts, and they've had some real issues. I spoke to the president of the Family Law Division of the High Court there, and he's indicated to me they've been locked down since September, effectively, or at least locked down out of, and it's, you always have these lovely sort of pictures of them, in their studies and things, but they're all working from home. It's been very difficult. They've had some difficulties with technology, particularly in some of the lower courts. But I think most of it, if not all of it's virtually all electronic. There are some very, when I say not unusual, but there are some rare occasions when they're doing things face to face. There are some rare occasions when they're going to court, but a lot of them are actually still working from home. So that's been a real issue for them, certainly in our jurisdictions. And I don't think they see it as lifting in any time, soon, which is quite extraordinary when you think of what they're going through and the volume they're going through. They've got 1,300 judges across England, and most of them are operating electronically, if not all of them. And that includes a lot of what our state courts would normally do with things like intervention orders and other things as well. And they've got magistrates as well as judges. So I think it's a huge impact on them. And I think at the moment, with the only thing that's saving them at the moment is the fact that the vaccine's been rolled out so quickly. Apart from that, I think they're still looking like at a massive backlog. So I think we're very lucky to really be returning to face-to-face hearings compared to most of the rest of the world. People are flabbergasted that we're now doing that more and more. I think the idea of having jury trials, even though there's a number of different courts being used in the state system, is just wonderful, because, you know, that's not being enjoyed. That level of justice is not being enjoyed in a lot of the rest of the world.
Mark, did you you want to add something? And if we're up to time now, so if you could make it, if you don't mind.
Just briefly, and because the Law Council is a member of the International Bar Association as well as the Commonwealth Lawyers Association, we've got pretty good insights as to where it are. Obviously, connectivity is a big issue abroad. In some of the continents, it is just impossible to have virtual hearings. But as the Chief Justice says, in those developed parts of the developed world, it's the courts with high volume amounts, particularly those dealing with family violence orders, restraint. We know them as apprehended violence orders or intervention orders. They are just so far behind. It is not funny. And really, in those jurisdictions where they have a robust system of issuing interim orders, based, you know, on an ex parte basis, even their orders are going on for months and months, and in some cases years, and that's a real problem in terms of access to justice. But as the Chief Justice rightly says, in many respects, we're the envy of the world.
Absolutely. Can I thank, we're at time now, could I thank our three panellists? It's been marvellous to hear your experiences. I'm very grateful not only for your time, but for your insights. I'm indebted to all of you, and I'd like to thank Mark, your committee, your Access to Justice Committee, that would ordinarily be doing face-to-face committees, and a wonderful idea. And this is one of four, the first of four that we hope to be doing over the year. Thank you all for your participation and attendance, and I hope to see many of you, well, see inverted commas, many of you at our future webinars. Thank you all very much.
Thanks, Jacoba.
Thank you.
Thanks, Jacoba.